Hello. Hello.
Good morning and welcome to today's press conference. I'm delighted to have Competition Commissioner Margrethe Vestager here with us today to present an antitrust decision adopted this morning. The Commissioner will present the case and then we will take your questions. Commissioner?
Well, thank you. Today the Commission has adopted a decision imposing interim measures on Broadcom. Broadcom is the world's largest designer, developer and provider of chips for fixed video and broadband devices. Interim measures aim at preventing irreparable harm to competition. They need to strike a balance between protecting the right of defence on the one hand and speed and effectiveness in antitrust enforcement on the other. They allow the Commission to order a company to stop conduct that we consider at first sight to be illegal. At the same time, the companies involved have the right to be heard before the measures are taken and can appeal them before the European courts. At this stage, we consider that Broadcom is restricting competition by engaging in exclusive and quasi-exclusive dealing with key customers. Broadcom's behaviour would cause serious and irreparable harm to competition. So today we have ordered Broadcom to stop its conduct while our in-depth investigation on the merits of the case continues. Most of us probably would have a TV set-top box or an internet modem at home. The brain inside such a set-top box or modem is called a system on a chip. That chip ensures that we can access internet or watch the news or movies we like on TV. Broadcom is the world leader in the supply of such chipsets. It accounts for roughly half of sales of the entire industry. In the second half of 2018, we received market information suggesting that Broadcom may be imposing exclusivity and quasi-exclusivity restrictions on its customers in relation to chipsets. Our preliminary investigation since then has shown that Broadcom seems to be dominant in 3 different markets. That would be the market for systems on a chip, for TV set-top boxes, for fibre modems and for XDSL modems. Market dominance in itself is not a problem. We value companies for becoming successful due to their skills, due to innovation. But dominant companies, they do have a special responsibility not to impair competition in the internal market. As an example, they cannot require or induce customers to purchase exclusively or almost exclusively from them. This is not competition on the merits, and it ultimately leads to a reduction of choice and innovation to the detriment of consumers. The first condition to order interim measures is that the Commission finds an infringement on the competition rules at first sight. During our investigation, we analysed several agreements between Broadcom and its customers. We found that 6 of these agreements feature provisions to buy only or predominantly from Broadcom. We considered it likely that these agreements would negatively impact competition in 2 ways. First, they strengthen Broadcom's position in dominated markets. As an example, this is done through exclusive purchasing obligations and exclusivity rebates. These effectively prevent competitors from challenging Broadcom's position in these markets. And second, they allow Broadcom to leverage its dominance in the market for cable modem chipsets, in which Broadcom may not yet be dominant. And this is done by granting commercial advantages to those customers in the dominant markets, which also buy exclusively cable modem chipsets. Broadcom's conduct makes it very difficult for the only other supplier of those products actually to compete. We have carried out an analysis of the likely effects of Broadcom's conduct. We conclude that these arrangements, well, they are likely to shut out competitors from the market. Our analyses are based on a number of elements, including the size and importance of the customer, the condition and duration of the agreements, and a substantial amount of internal documents submitted by Broadcom's customers and competitors. On this basis, we have reached the conclusion that at first sight, or in legal lingo, prima facie, Broadcom is currently infringing competition rules by abusing its dominant position in the system of a chip market on TV set-top boxes, fiber modems, and XDSL modems. The second condition for the Commission to impose or order interim measures is the need for urgent intervention due to the risk of serious and irreparable harm to competition if the infringement continues. And we consider this condition to be met. The evidence that we have gathered from Broadcom's behaviour is likely to have severe negative effects on competitors before we could reach a final decision. We know that telecom and cable providers, they will launch a large number of tenders in the coming years. We believe that if Broadcom's contractual arrangements stay in place, Broadcom's competitors would not be able to compete on equal terms in those tenders. That could fatally affect their viability. Their revenues will fall, and so will their ability and incentive to innovate. Their products will therefore gradually lose attractiveness in the eyes of customers. They will progressively be marginalised and may ultimately be forced to leave the market. If that happens, European customers would face the consequences of higher prices, reduced choice and less innovation. In today's decision, we have therefore ordered Broadcom to cease to apply the exclusivity and leveraging provisions contained in its 6 agreements with manufacturers of set-top boxes and modems. Broadcom must also refrain from including the same provision in any future agreement with these manufacturers, and refrain from implementing other practices that would have an equivalent effect. And Broadcom must comply with these measures within 30 days. The measures will be in place for up to 3 years. They are appropriate and proportionate to address our concerns regarding the proper functioning of competition in the relevant chipset markets. They do not prevent Broadcom from continuing to supply its chipsets to its customers, but they will ensure that Broadcom's competitors are able to compete on the merits while we complete our investigation. This investigation started October 2018. So it has taken us 1 year to adopt today's decision. During that time, we have carried out a thorough investigation by sending Broadcom and third parties several requests for information. In June this year, we issued a statement of objection. To this, Broadcom replied extensively in writing. Broadcom also had the opportunity, and used it, to be heard in an oral hearing. Moreover, Broadcom has the right to challenge today's decision before the European courts, where it can also ask for a suspension of the interim measures. And of course, in parallel, Broadcom has the full right to defend itself on the merits of this case as the Commission's in-depth investigation continues. Proving our case to the necessary legal standard cannot be compromised, and respect for rights of defence is absolute. So, interim measures, they are one way to tackle the challenge of enforcing our competition rules in a fast and effective manner. And this is why they are important, and especially that in fast-moving markets. Whenever necessary, I'm therefore committed to making the best possible use of this important tool. Thank you.
Thank you, Commissioner. Before we turn to your questions, let me point out that we have experts in the room for any more detailed technical questions you may have on background afterwards. And let's start with, as usual, with the questions specifically on the case.